Hello and good morning or good afternoon, since I don't know when you will be listening to this video, to everyone following my presentation on some recent rulings from the Court of Justice of the European Union and the European Court of Human Rights, which impact audiovisual media services or the media in general in Europe. Those of you who are familiar with the format will know that once every year, the European Academy of Law, the ERA, with seat in Trier, and the Institute of European Media Law, the EMR, with seat in Saarbrücken, organize the annual European Media Law Conference, usually in May or June in Brussels. This year, according to the circumstances, we could not organize it as an on-site conference, so instead we had a kind of an update seminar which focused on the issues surrounding platforms and legal implications that new rules might bring in the European Union. As an add-on to this workshop or the seminar, which you can find further information about on the website of both the EMR and the ERA, I am today going to provide you with what usually is the last session of the conference, and that is the update on relevant jurisprudence, relevant case law since the last conference. So in other words, what has happened since May 2019 until now. And I will do so as a video recording, so what I don't have today is the audience feedback that I usually get, but I hope that this video supplement to the conference will nonetheless be useful and dynamic. And I cannot ask you to ask me questions after the presentation, but I hope that I'm clear enough that it helps you to understand better what is relevant. Why did we decide to do this recording in addition to the little seminar half day that we had a few days ago? The reason is simple. 1 year of Court of Justice jurisprudence and Court of Human Rights jurisprudence in our field is already so vast that if we would skip it for 1 year, next year I would have to dominate the conference for half the day to catch up. So today I give you an overview which will take roughly 1 hour and hopefully leads you to being as up-to-date as possible and then being ready for next year when we hopefully can organize the conference again in person. I will start with the overview how I'm going to do my presentation, which follows the same structure every year, and that is I first return to those cases which I already mentioned in the previous year and where we maybe only had an advocate general opinion, or maybe there was only a reference, and I can go into more details now. And then I will give you an overview of newest cases from Luxembourg, which means the Court of Justice, but also some opinions that we've had in recent months from advocate generals where the decision will be forthcoming in the next couple of months. And then we also have an outlook for cases where there's only been a reference until now and which will be decided probably not until half a year or maybe even a year from now. And finally, I will give a very brief overview of cases in Strasbourg, so the European Court of Human Rights, but there I have to already now say I will really only touch a few cases because, as most of you will be aware, the Human Rights Court in Strasbourg has a huge amount of cases to decide on, and the caseload concerning Article 10, so the freedom of expression and for us relevant freedom of the media, as well as Article 8, the private life or privacy right, is so vast that it would be really difficult to even say I take only the most important cases. So what I do is I take a selection to give you an idea what is happening there that impacts the media sector. With that, we start with the leftovers, as I call them. Last year, as a reminder, we had a case mentioned that concerns Apple. It was a case about an amendment to the German film funding law, which took place in 2014, and which introduced an obligation for levies, which until then had only been applicable to television broadcasters and also to cinema services, but levies that basically provide funding for German film productions. And this obligation was extended to video-on-demand services, but also to video-on-demand service providers which are established outside of Germany, so not under the jurisdiction of Germany. And just to point that out as well, as a flip side of the coin, these providers could then also apply as potential aid recipients. So basically the funding that was accumulated under this film funding law is then handed out again to film producers, and in this case VOD service providers outside of Germany were also legitimate applicants for such funding aids. However, Apple, that is not under German jurisdiction, contested that the Commission decision which authorized the German law was in actual fact correct. They claimed that there was an incompatibility with EU law. And the decision of the General Court, which I introduced last year, dismissed the application. It didn't even go into the substance of the case. It just said it's inadmissible because, as it was mentioned, the applicant failed to prove that it was individually concerned by the German law. And as you will know, only individuals that are directly concerned by EU decisions, for example, decisions of the Commission, can actually go to the General Court. So it basically was over the case. But Apple decided to appeal it to the Court of Justice of the European Union, but before the court could even consider the case in appeal, Apple discontinued the appeal, and then the case was removed from the register of the court. So the case is over. The inadmissibility decision of the General Court becomes final. And the reason for this, the possible background, be twofold. One is that the Audiovisual Media Services Directive was revised in December 2018, and it now includes explicitly such a possibility that member states, if they do have levy obligations, can also extend these levy obligations across borders, meaning to providers which have their seat somewhere else, but also are addressing the local market. And another reason may be that there was an agreement found between the Filmförderungsanstalt, so that's the German institution that takes care of the film fund, and Netflix, so a competitor of Apple, that basically had agreed to start paying this levy fees already under the old German law, and therefore maybe there was like a model for also other providers such as Apple to do so. So that case is over. The next case of interest is the Baltic Media Alliance case. Again, I had already mentioned it, so I just remind those of you that already listened last year to my presentation that it is about a television provider, Baltic Media Alliance, under UK jurisdiction, which broadcasts a television channel called NTV via Lithuania, and that is intended exclusively for the Lithuanian public, so registered in the UK. You know, the country of origin principle of the Audiovisual Media Services Directive allows that, but it basically targets only the Lithuanian public. But what is interesting is it shows the programs mainly in Russian language, so it targets obviously a specific interest also. And the Lithuanian national regulator, the LRTK, adopted a measure which imposed on operators that broadcast television channels to Lithuanian consumers via a cable network or via the internet that they would, for a certain period of 1 year, cease to broadcast this specific television channel NTV via Lithuania, except if it is included in a pay-to-view package, so not on what we would call free TV. And the reason was that the regulator had declared that the broadcaster, or one of the programs that was broadcast on NTV Lithuania in 2016, contained information that incited hostility to the Baltic states or even hatred on grounds of the nationality, and therefore declared that it was like a punishment that for a temporary period of time this program would not be available on free TV but only in pay-to-view packages. And the Advocate General had already delivered his opinion last year, which I talked about, and said yes, the regulator was justified in taking action against the program. The measures that were chosen were proportionate, and they were compatible with the fundamental freedom to provide services as it is laid down in the Treaty on the Functioning of the European Union. Why? Because the AG said that Lithuania legitimately sought to protect the Lithuanian information space or the information area from what you maybe would refer to as Russian propaganda. And he mentioned that that's happening in the context of a kind of an information war to which Baltic states are subjected. And It's a very interesting case because if you think about the political discussion at the moment about disinformation happening online and how potentially users and readers are misguided, think for example of the COVID situation at the moment, then this kind of reminds us a little bit of the potential possibilities what could happen. But again, remember here, it's a television broadcaster, and for that there are very specific measures foreseen under the national laws transposing the Audiovisual Media Services Directive. And the question here was only whether it violates EU law. And the final judgment of the court, which was handed out about a month after our conference last year, says actually this whole situation doesn't even fall under the Audiovisual Media Services Directive case, because all that happened is that there was one specific way of transmission or broadcasting that was prohibited or interrupted for 12 months, but generally speaking the program could still be distributed in pay-per-view packages. So all that the user would have to do is take out such a subscription, and then they could continue to see the program. And therefore they said the free flow of information as the Audiovisual Media Services Directive guarantees it is not affected, and we don't even have to test the derogation, the exceptional derogation rules. The country of origin is respected, it is no problem, and that answers the question of the referring court. There's also some leftovers concerning ISPs or platforms or intermediaries, as you may want to call them. We had a case which I already introduced previously, which was the Uber Spain case. Now you might think, what does Uber have to do with media? Well, not directly, but it concerns an ISP, and ISPs obviously in the area of the media have a very big relevance, or as I would refer to them, platforms. In the case of Uber, you all know probably the service Uber. It was about this offering of transportation services, but the question was, is Uber only an intermediary which falls under the e-commerce directive? That was the perspective of Uber. Or is it a transportation service? That is what the competitors, taxi drivers, were of the opinion. And it's very important because depending on which category you fall, you have different obligations to meet. And the Court of Justice developed some criteria to decide when a sharing economy platform is or is not to be considered as an ISP, or you could also say as merely an information society service. One is, one has to see whether the role of the platform for the end service, as you may want to call it, is indispensable. So Uber is more than just an information society service if the transport service that is actually offered at the end needs Uber as a platform, whether it depends on Uber as a platform. And the second element is whether there is a control over this end service. And in actual fact, Uber determines the fares, the quality of the vehicles that have to be there, the conduct of the drivers, and so on. And thereby the court had concluded Uber has control over the transport service. That's why it is a transportation service and not only an ISP, which means more obligations for Uber. And now comes the new case, which is quite interesting, Airbnb. There was a decision handed down last December that concerned, again, a sharing economy platform, an intermediation service, where the question is it the same like Uber? Because here it is about a provision of accommodation or not. So is it merely under the e-commerce directive, or is there additional obligations that possibly Airbnb has to fulfill? And here the court said, well, the service is not aimed at providing the actual accommodation service. It is more a tool, a platform, which people can use to present, on the one hand, and for the ones that are seeking accommodation, find accommodation which they can rent for days or weeks or whatever. And therefore, it is more of what you maybe would say a technical facilitation, but not an actual control of the service. So the Uber and Airbnb cases are different in the outcome, which means in the case of Airbnb, it is only an information society service, not anything more. So in the concrete outcome, they're different. But if you look at the two together, you can already get new indications on what can be regarded as a pure online platform and what is more than just an online platform. Another extremely important case where we could not yet report about the final outcome last year concerns the case of Glavišnik-Piszczek, better known as the Facebook case. In the Facebook case, there was a politician in Austria from the Green Party, and it requested Facebook to remove comments which were defamatory in their nature, but not only a specific or a number of specific comments. The claimant argued that Facebook should remove any identical comment, so if somebody else repeats exactly the same comment, or also equivalent comments. So a defamatory statement can be, there can be a variation, but it can still be defamatory, so equivalent comments, and both in Austria as well as worldwide, basically making it impossible for anyone in the world to access these comments. And in the decision of October last year, the Court of Justice basically defined a more wide scope of monitoring obligations that social media services have, and social media services qualify as so-called information society services under the e-commerce directive, and therefore this judgment is absolutely fundamental. It's a case of very high importance because it starts shifting a little bit stronger the role of platforms already under the existing e-commerce directive framework. And this may also be a first step towards a new future which will be politically structured or politically shaped by the Commission, the Parliament and the Council, if they may possibly agree in the coming years on what is currently being discussed as the Digital Services Act, or a package of directives under such a Digital Services Act package. In the case of Facebook anyway, the Court of Justice had to deal with the question of whether European law precludes that under national law by a national court, a host provider, such as in this case Facebook, is being ordered to remove, as I said, not only a specific comment, but also identical or equivalent comments by others, if that original first comment has already been declared to be illegal. And the findings are as follows. The court said, yes, clearly host providers can be ordered to remove exactly the same information, even if it comes from someone else, or if they can remove it, block access to the information. But it goes one step further, the Court of Justice, and says also equivalent content. So not only if, and I'm not going to use any bad language because I don't want to be in trouble in terms of defamation, but imagine that you say something very negative, which is defamatory about another person, and then somebody else says in different words the same type of defamation. Then the court says if it is equivalent, it can be ordered that any equivalent comment is also removed. But there is a disclaimer, or there is a limitation, and it says that this only is possible if it's provided that the content is essentially unchanged. So not any similar type of comment, but it must be more or less the same like the original content. So maybe only the bad language is changed. The difference in the wording compared to the original wording has to be so small or of a nature that it is not necessary that the host provider has to do a completely new independent assessment of whether this new content is also defamatory or illegal. It basically has to immediately be able to spot, well, this is the same like the other comment. The reason why this is so relevant is because, as you can imagine, it determines how much oversight a host provider has to ensure over the content shared via his or its platform, because if they have to spot something that is not very similar but different, even though also defamatory, then it would mean that they have to be more proactive in the monitoring. If it is very similar, there might be ways of identifying this similarity. So it's a very important case, which at least opens up the door to more active roles of the platform providers. The next step the Court of Justice didn't do. The question was, would it be able to completely put a monitoring obligation for any type of content concerning one person on a platform, and the court obviously didn't want to go that far, because otherwise there may be an issue with Article 15 of the e-commerce directive, which says no general monitoring obligations are possible. But what is interesting is that it did follow the court's, the referring court's question, could this also be extended to removal of the information worldwide? And the Court of Justice said yes, in principle that is possible. However, if you do foresee such a possibility, then the courts in the member states, so the obligation is in the member states, but obviously the courts have to do it then, have to take relevant international law into account if they do apply such an injunction or such an order towards a host provider. So how it is done in concreto depends on what the national member state courts do, how they formulate the obligation, but at least from EU law perspective it is not impossible, and again that indicates this Glawischnik-Piszczek case has a fundamental importance for the development of platform liability and responsibility also in the future. Okay, let's see. What have the Advocate Generals at the Court of Justice been doing in the past couple of months that we have not yet covered until here? There's one new judgment first, sorry for that, that concerns Google Mail. So in June last year, actually a few days after our conference, the Court of Justice handed down one very important decision, which had a certain similarity to an earlier case concerning Skype. But I will get back to that in a moment. So the case facts of Google Mail are as follows. The German telecoms regulator, the German Bundesnetzagentur, said Gmail is the top service, but it actually is more than that. It's a telecommunications service, and therefore it has to register with the Bundesnetzagentur. The court, which had to decide about this question because the Gmail service challenged the decision of the Bundesnetzagentur, said, no, Gmail is a service which is indeed provided for remuneration, even though it's not directly paid for. It consists wholly or mainly in the conveyance of signals via electronic communications networks, but any other content-related aspects of the services are not directly important or not as important as those technical ones. However, whether or not it falls under the definition of a telecommunication service which is subject to a registration is something that the National Court would not be able to answer. Therefore, it asked the Court of Justice. And the Court of Justice had previously ruled on the Skype case, which, as all of you will know, is a voice over Internet Protocol service, that a software publisher of a feature which offers such a VoIP, which allows also communication with fixed or so landline or mobile numbers, and not only in between VoIPs, and therefore is subject to a national numbering plan, the numbers which are called, that makes it an electronic communication service. So relatively strict in saying, yes, Skype is similar to what used to be a regular telephone service, and therefore falls under this definition and is subject to a registration. And you could think, if you see that, well then mailing service online maybe is something similar, and it's very relevant because of the obligations that come with it. But actually the Court of Justice said no. Google Mail, or a mail service like Google Mail, is something different than a VoIP service like Skype. The ruling is relatively straightforward and says the main effort that Google Mail does is not the conveyance of signals on electronic communications networks, and therefore it doesn't fall under the Framework Directive, which in the meanwhile is part of the European Electronic Communications Code. The argument is that a web-based email service does indeed actively participate in the sending or in the receipt of message, but his role alone is not sufficient that that service works on a technical level. You need an access point, and that's things that don't necessarily come together with the Gmail service, and that's why it would be too much to assume that it is an electronic communication service. The next case is actually three cases. It's a copyright, the German copyright triple, as you may want to call it, The judgments handed down all on one day, last July. Very famous, all three cases, a huge discussion in the IP community. It's copyright, and as you know, the ERA offers specific copyright seminars and annual conferences, so I'm not going to go too much into detail, but they're very relevant because each of them has an impact on the work of journalists and the media. So the first of the cases, the Spiegel Online, or better known as Volker Beck case, where the applicant was the author of an article dealing with, one can say, somewhat sensitive but especially controversial questions. And that was a chapter in a book, and he later claimed that the editor of the book actually changed his contribution without his permission. And Spiegel Online, being a German weekly, published his original text and the complete text because they wanted to show that this claim of the author that it was changed without his knowledge or without his permission is not true, that the original manuscript basically had not been falsified by the editor of the book. And all of this dates back decades. The original publication in the book. And the German weekly discussed this whole issue because the person, Volker Beck, is a politician, and as I mentioned, it was an extremely controversial issue that he was dealing with, the question of how one should position from a political perspective, the question of sexual relationships with minors. And so it was something that he obviously was not very happy with, that he had a history of having commented on this topic. And this German weekly basically reproduced the text in its entirety to show why his claim that he was wrongly understood or that his text was falsified is not true. Obviously, as all of you know that are copyright experts, or even the ones that are not experts, it's obvious if you reproduce a complete text, that may be a copyright question. We'll come back to the decision in a moment. The facts of the case in the second one are very, in a way, entertaining because it's about music. But to be honest, it's remarkable how 2 seconds of music can follow into such a history of jurisprudence as it's the case in the Kraftwerk or Pelham case. German music group Kraftwerk, avant-garde electronic music group of the 1970s. Those of you that know them may know that they are kind of co-inventors of the synthesizer. They published a piece of music, Metall auf Metall, and as the name suggests, it's basically contains a piece which metal touches metal, or at least the sound of that is reproduced. 20 years later, Moses Pelham, a German producer, used a 2-second sample, so a very short, something of that kind, sample from the song, and made a loop out of it in one of his songs, which was performed by a hip-hop artist. So completely different sound to it, but if you listen to it and you identify the 2 seconds, you can actually find that they belong to this original song. And this sampling case went through all instances under German courts, German courts, went right up to the Federal Constitutional Court. It was twice at the Federal Supreme Court, and then it finally reached the Court of Justice, and I will again tell you the outcome in a second. The third case of the triple is the Afghanistan Papers case. It's a bit more simple, the case. There was a media company that published several confidential reports that were or that belonged to the German Ministry of Defense about specific information concerning Afghanistan. And the ministry didn't rely on a breach of secrecy or something like that violation, but claimed, well, this was not possible, such a publication, because it violated its copyright. And all 3 cases obviously have quite an impact on potential use of other people's works, if they constitute such works. So let's look first at Spiegel Online, Volker Beck. Here the court said, if a protected work is used in connection with the reporting about current events, then it cannot be necessary to ask the original author for prior consent. So in this case, obviously, if Spiegel Online would have asked Volker Beck, he probably would have said, no, you cannot use my original text. It was necessary from a journalistic perspective that they can use the text without asking for prior consent. And in addition, it is not necessary that a quotation of a work, because that's one of the exceptions to copyright where you don't have to ask for a permission, is visible as a quotation in the sense that it is inextricably integrated into the text, for example, by pasting the relevant paragraphs and putting it into your own text or putting it into the footnotes. No, you can also just have a link to the original document or put the original document somewhere else, and then it still can be a quoted work. So basically, Beck lost his case. Spiegel Online won in terms of a journalistic reproduction not falling under the copyright restrictions. In the Kraftwerk-Pelham case, the 2-second case, the court was very straightforward and said, phonogram producers, because in that case the 2 seconds were taken from a CD, so it was not so much the question only of the original author, but it was a question of the phonogram producers. They have an absolutely exclusive right to authorize reproduction, even if it is the shortest of short excerpts, like in this case 2 seconds. And if a user, in this case Pelham, uses one of these short sound samples and embodies it into his own music work, basically in doing so exercising his freedom of the arts or his freedom of expressing himself in an artistic manner, if it happens in a modified form which is unrecognizable to the ear, then it's not a reproduction. So basically, if you cannot identify it where it comes from, then it does not have to be regarded as a reproduction, therefore it's not illegal. If you can, however, especially in a phonogram, say it's this exact excerpt, then it is a reproduction and needs authorization, and that is for the National Court to decide after giving it back from the Court of Justice. And in the Afghanistan Papers case, there was a clear conclusion of the Court of Justice that neither freedom of information nor freedom of the press are additional derogations from copyright. So the exceptions that are laid down in Directive 2001/29, so the harmonization of certain aspects of copyright for the Information Society Directive, is that the exceptions, the derogations mentioned there are final, and therefore such an additional exception under national law is not possible. However, military status reports typically are not copyrighted works. They can only be copyrighted or can have copyright protection if there is an intellectual creation in it. So if the author's personality is reflected in it, if creative choices have been made. And that is not something that is typically, a military status report does not typically have that. Okay? But again, up to the National Court to finally decide. Another case, and this year many cases originated in Germany, it's pure coincidence, but another case from Germany concerned the VG Media. Just a moment. The VG Media case was decided last September. There was a new law introduced in Germany in 2013, so a revision of the copyright law, which aimed to protect newspaper publishers or magazine publishers in their copyright. Association taking care of copyright management organization, a CMO, taking care of the rights of such publishers of newspapers and magazines, claimed that Google infringed this new right by showing snippets in the search results. So if you look for a news item, for example, update on COVID measures, and then you check out Google News, you will get snippets which already include a few lines of the actual search target. If you then click on the link, then you come to the full text. And the problem was that this new law had not been notified to the Commission under the so-called TRIS directive, the Directive 2015/5035, which says any information society service directed law, so any law which has specific rules which aim at such information society services, has to be notified in its draft status to the Commission so that the Commission can first analyze whether it is potentially in conflict with EU law, but more importantly, whether the Commission maybe is planning to propose an own law in that field. And Germany had not done that. And the court said, if you don't do that, it means any individual before a national court can say this law is not allowed to be applied because it is formally incorrect, because it was not notified. Now, the decision won't have a big effect. It did have the effect that the original German press public right is not immediately, doesn't take immediate effect. But now we have the EU copyright reform with the new directive on copyright in the digital single market, and actually that directive itself in Article 15 now introduces the possibility for member states to introduce such a press publisher's right. So in a way, Germany can reintroduce the right, and there is no obligation to rely on the old draft law, which had not been notified and therefore could not take any effect. So it's only a technicality, but it's quite interesting because it delays the introduction of this right by several years. Another area where we have a lot of developments every year concerns the data protection or privacy rights. And again, some of them are very relevant for the media sector, especially when it comes to what types of information can, for example, newspapers hold in their archives, or which types of information can be referenced in search results. The famous question of the right to be forgotten online and how it was developed in the Google judgment of 2014. And in that context, we have basically two important developments of last year. Both concern the French Data Protection Authority, the CNIL, and both concern Google. So in the one case, CNIL had fined Google because Google had refused to dereference a certain search result to all its search engines domain name extensions. In other words, it did take it out of the list of a FR search engine, so google.fr. If you typed in a certain search, you would not get a certain result because there had been a request for dereferencing. But if you would go via google.com, you would still find the result. And the CNIL was of the opinion that this is not okay. A dereferencing request means it has to be basically taken off globally. And the Court of Justice said that EU law does require a search engine to take down or to delist such results on all versions of its search engine which are within the EU member state, but not globally. So basically the then 28, now 27 EU member states, domain name extensions have to be respected. In there, you're not allowed to find it any longer, the search result, if there was a dereferencing request successfully. But globally, it's something that EU law maybe cannot stretch out as far as that. The second CNIL versus Google case concerns the fact that here we have several applicants that had asked Google to dereference, and they were unsuccessful. And then they approached Data Protection Authority and said, we are of the opinion that Google should have dereferenced, and CNIL refused to serve a formal notice in those four cases concerning how the search results are displayed. And therefore these applicants went to the French Conseil d'Etat, and the Conseil d'Etat asked the Court of Justice on its opinion. The results concerned different, how shall I say, search results which are not advantageous for the individual applicants. One case, it was a satirical collage of photos, and another one, there was a suggestion that there had been a relation to the Scientology church of an individual concerned. Another one was about criminal hearings concerning one of the persons affected, and a sentencing that had followed. So basically information that these applicants would have liked to not be able to be visible when you search. And the question was it correct that CNIL refused to do that, not to ask Google to dereference? And basically it's quite an extensive decision. I won't go into all details, but the important aspect is that it has defined a little bit more clear how the right to be forgotten or the dereferencing functions, especially how the balancing has to take place with the freedom of information of any internet user to find out what these four individuals have had for either suspicions connected to them or actual events in their life. So this balancing between the interest of the privacy of those four individuals versus the interest of any internet users' freedom of information has to be done by the search engine, and the court gives some further indications how this has to take place. It mentions that all circumstances must be taken into consideration. For example, if it's a very serious offense, there might be more right of the public to be informed about it. If it's petty theft, for example, maybe not. The distance between the search that is taking place and when the original crime, for example, happened, and generally speaking, the public's interest now when the request is made to find the request for dereferencing to find out what that person actually did in the past, and also what consequences a publication would have for that person. So, in other words, the court is beginning to carve out a little bit more detailed how to deal with the right to be forgotten in practice. Okay, there's a lot of other cases which we could be dealing with in the same detail. We don't have the time. I will just give you an overview so you can see how much has happened in the last year. There's a huge amount that is relevant. Each of these cases, if you're interested, you can find obviously more information by following the links to the cases, but I will briefly try to summarize. One of them concerns, again, Google, but completely different case. It's about the fact that in Hungary there is a tax concerning advertising, which is issued in a bit of a different manner to nationals and non-nationals. And when I say nationals and non-nationals, I mean companies established in Hungary or outside of Hungary. And the court said, although it is okay in principle that you have different rules, because, for example, the domestic providers may already anyway be subjected to some form of tax registration. So although it's okay to have in principle different rules, the fact that the penalties basically only concerned non-domestic providers, in this case Google had been fined, that is not okay, and it's a violation of the free movement of services according to Article 56 following of the Treaty on the Functioning of the European Union. So the Hungarian tax system concerning the advertising online is not compatible with EU law. A very important case, which again shapes a little bit further the role of platforms today, is the Amazon Marketplace judgment, or the Coty Germany case. Coty has several times been involved in cases, so maybe Amazon Marketplace is clearer. In that case, Coty distributes certain brands in perfumes, especially expensive luxury brands, and claims that Amazon had infringed trademarks because there was fake or plagiarized, if you want, Davidoff hot water perfumes, and these counterfeited products were stored in warehouses of Amazon because it actually delivered the products on behalf of a third party via the Amazon Marketplace to the individual customers. So Amazon is basically the fulfillment provider, and the question is, as Coty Germany claimed, is Amazon therefore also the infringer if there is a trademark violation, or is it only the intermediary between the infringer that originally is selling the product and the user that is buying the product? And obviously that's important because it depends on where you can get your damages from. And the Court of Justice said a company which stores goods for someone else doesn't infringe trademark rights per se. It only does so if it pursues the aim of offering the goods for sale itself, putting them on the market itself. But in actual fact, what Amazon is doing, according to the court, is that it is only storing them. But it is important because a kind of a secondary liability of online marketplaces can happen if there is an interest of the companies to offer the goods themselves. Another case overview, or two cases concern one, ebooks, better known as the Tom Cabinet case, where there was an online service which basically was like an online book club, with the difference that it concerned ebooks. So people could buy ebooks which were licensed by Tom Cabinet from Tom Cabinet, and then read them and sell them back to Tom Cabinet as used ebooks. And then eventually the service was changed a little bit, and it was possible via subscription to have access to other people's used books. And the question was whether the one-off licensing of a book leads to the possibility of having it sold as used book, similar like you can do it with printed copies, or whether in the digital context it has to be regarded as a communication to the public if a second-hand ebook is sold through a website. And if so, then it's obviously a violation if there is no authorization of the copyright holder, the original author. And yes, the court said it is a communication to the public, and therefore the reading club of Tom Cabinet is subject to an authorization by the copyright holders and cannot just share so-called used or second-hand ebooks. Obviously, used and second-hand ebooks is a bit an odd description, because an ebook stays an ebook stays an ebook no matter how often it is read, other than maybe a paperback copy which after several readers looks a little bit damaged. Another important case is a TV Play Baltic case, also of last December, like the Tom Cabinet decision. Here we had a situation where national law introduced so-called must-carry obligations, where the question was whether that case, satellite provider has to include in its package of TV programs one specific program. And again, it's in Lithuania, so you already know the regulator from the case that I mentioned previously. They refused to allow an exemption for a specific satellite package provider, TV Play Baltic, to include the television channel LRT Kultura, so obviously a cultural channel, and said, no, you have to rebroadcast that as well in your packages. And the question was whether that is okay under EU law, and the Court of Justice clearly said yes, member states are free to impose must-carry obligations on undertakings that offer, in that case, the live streaming of a TV program. So it's a little bit of variation of old must-carry decisions. It went a bit further and said Article 56, so free movement of services under the treaty, does not preclude member states from imposing such a must-carry obligation on this very special type of provider. It's an operator offering a package of channels via satellite, such as was the case for TV Play Baltic. As long as the restriction is justified, and yes, must-carry obligations for the promotion of cultural channels is something that can be regarded to be justified. Finally, a few or two data protection related updates from Luxembourg in addition. Just briefly, Planet 49 was a judgment last October which concerned the question whether checkboxes which are pre-ticked, basically I consent to something and it's pre-ticked, whether that meets GDPR requirements for obtaining consent if you are visiting a website that uses cookies, or if that is insufficient. And the court clearly said no, pre-ticked checkboxes are not acceptable under GDPR, and in addition it went further and said before third parties can access cookies, you have to inform the user how this access takes place and how cookies stay active on the terminal device. So there is an obligation to quite clearly inform before a user can consent in a proper way to the use of such cookies. And then there is the judgment of Fashion ID of last July, and here it was a much discussed case because the question was whether somebody that uses Facebook plugins, so in that case the like button, on their own website automatically becomes a joint controller of the data that it is processing with Facebook, although typically the data via this plugin is collected from an end user and then directly shared or transmitted to Facebook. And the court here said, yes, there is a joint responsibility because there's joint control, and that means you as a website operator, if you use such social media plugins as the like button, have to make sure that that like button complies with legal obligations. In other words, you have to make sure that you know what Facebook is doing, and you have to make sure that your users know, if they visit your website, the data that is being created will be transferred to Facebook. You might know that these like buttons were programmed in a way that already information is sent even before you actively click on the like button. So here clearly both cases are very data protection friendly and make clear that GDPR, but also the predecessor law, is strongly protecting individuals, and only if there's valid consent there can be a justified or legitimate processing of data, or there is one of the other legitimate purposes which do not apply in this case. Now I'm back to what I briefly said wrongly before. Here we have the Advocate General opinions that have taken place in the past couple of months, and there I have decided to limit myself to just 2 or 3 sets, but all of those are extremely important in the sense of they will probably be decided in the coming months, and they will have quite a strong impact on the media sector. One is, or could have quite a strong impact. One is the Vivendi case of last December. It's a question about a merger or an acquisition of one media company by another, so a French company taking over a large amount of shares in Mediaset Italia. The Mediaset complained to AGCOM, arguing that this acquisition of shares bit by bit, which amounted up to 28.8%, was illegal because it contradicted legislation that safeguards information pluralism. And the Advocate General, we don't have the judgment yet, the Advocate General says, in general, information pluralism is a legitimate reason that can justify restrictions of the freedom of establishment. So basically blocking certain types of acquisitions or the amount of shares that you can acquire, as long as the national law is proportionate. And in the specific case, the AG comes to the conclusion that the Italian legislation defines the electronic communications sector too restrictively, because it doesn't take into consideration new markets that are important today to access media. And that's why the Advocate General suggests to argue that there is a disproportionality here, although he does say it is possible that information pluralism is a justified legitimate for member states to restrict freedom of establishment. In addition, it also seems that the way that the revenue of affiliated companies is calculated is too strict, because basically it's any affiliated company is regarded as if it was a controlled company by the main company. And so, in other words, the suggestion is the Court of Justice should find the Italian media concentration law to be incompatible with EU, and we will have to see whether the Court of Justice follows this or not, and especially how it defines the possibilities of member states to use media pluralism as a means to restrict the fundamental freedoms. We have a number of cases, both where we have already an AG opinion, but also later you will see where we only have the preliminary reference that has been initiated and no decisions yet, which concern data retention. And data retention is, as you know, a saga before the Court of Justice of the European Union. Whether or not the rules are different if the data retention is done by national security authorities. So if the decision to store is because of interests of national security, or as in some of the cases, combating terrorism, whether that makes a difference to other cases where it is about combating serious crimes. The main questions were, do obligations that are imposed on telecoms providers in the name of national security fall within the scope of EU law, or is that something which is completely exempted because national security typically is something that is not under EU law, it is within member states' competence. And secondly, if it does fall under EU law, if there's a relevance of EU law, what requirements does the EU law set for such laws? And the AG opinion is a very interesting read. There's, as I say, several cases because they slightly are different, but the gist of it is all the same. And it says, whenever member states seek to impose any type of requirement of electronic communication services to process the user's data, to retain the user's data, EU law applies. Even if those obligations are motivated by national security concerns, you have to look at the other side, and that is the obligation on the electronic communication service providers, and that's why it falls under EU law. Limitations on the obligation to guarantee confidentiality of communications by these service providers have to be interpreted very strictly and always take into consideration fundamental rights. And therefore, in the suggestion to the court, the Advocate General says any type of retention of data should be very limited. It should be strictly for a specific purpose, and also the access to that to that data should be, the use of that data by other authorities should be very limited. And in principle, the Advocate General tries to say we have already a decision or two decisions for this matter, and that's the Tele2 Sverige and Watson judgment, and the criteria which were developed there should just be upheld. We will see how the court deals with these cases, but it certainly is not the end of the story about data retention. The next case is concerns again copyright, but it's a formal aspect of copyright, and that is it's a dispute which concerns a refusal by YouTube or another company, Google, to provide certain information that a film distribution company, Constantin Filmverleih, requested, because they said several users have put films online on YouTube in breach of their license rights or their exclusive exploitation rights. And that's why, in order to be able to approach these users and make damage claims, Constantin Filmverleih asked for email addresses, telephone numbers, and IP addresses of those users. And the Advocate General, in the reference that has been put to the Court of Justice, suggests to say, no, the Directive 2004/48, which is about enforcement of IP rights, clearly says that names and addresses of potential infringers have to, under certain circumstances, be given to copyright holders who want to make a damage claim. But names and addresses does not cover email address, does not cover telephone number, and does not cover the IP addresses of those users. That's the suggestion the Advocate General makes in his opinion. That's basically what has happened between last June and this June, what is extremely important in Luxembourg, but I cannot tell you that's it, because there are several more cases which are pending, where we either only have the application, or there may be still the oral hearing, or we do not have an opinion of the Advocate General yet, but they are nonetheless extremely relevant. And one of them concerns a fundamental issue of media law, which in a way also is relevant in the Vivendi Universal case that I mentioned. And that is the case of Fussel, Modestraße, Meyer. The applicant is a fashion company that operates in Austria, but an Austrian company, but also in Bavaria, and it wanted a German television broadcaster to transmit an advertising spot on its program. And it's a federally televised television program, but Fussel was only interested to have the advertising inserted in the regional dissemination in Bavaria, so basically in the cable network in Bavaria, ProSieben goes into cable network in Bavaria, because that was the only area where they were active. And the defendant in the original case, ProSieben, refused to insert the ad. They said, we can't do that because legally we are hindered to offer so-called regionalized advertising, because the German broadcasting law says a national broadcaster or a nationally disseminated broadcast program has to be the same across the whole entire member state Germany. And obviously the television provider had an interest to be able to do it, but said at the moment we cannot do it, and had hoped that it happened, that the national court would ask, the national court where Fürstenwalderstraße Meyer approached and said we would like ProSieben to insert this advertising, that this national court would refer the question to the Court of Justice. And this is what has happened. And in essence, the referring court wants to know whether this restriction under German broadcasting law constitutes an infringement of EU law, so free movement to provide services, but also whether this infringement, if it is the case, is justified. And it's actually it touches a fundamental question of distribution of competences between the EU and the member states, because rules on how to ensure information or media pluralism is something that typically is within the realm of the member state. And the question is whether fundamental freedoms should overarch this competence or not. And in my opinion, this is going to be a very important outcome if the Court of Justice actually goes into this question and doesn't try to answer the question without approaching the essence, which is media pluralism within the competence of member states. And if so, how much can member states decide under their own discretion on how to reach media pluralism? We have several pending cases concerning copyright and platforms. I will keep it short, but I do want to mention all of them because they're forthcoming. One of them is the Puls 4 TV case. The core question in that one is whether the hosting provider liability exemption under Article 14 has to be interpreted in a way, Article 14 of the e-commerce directive, has to be interpreted in a way as meaning that the operator of an online video platform, such as YouTube, for example, plays an active role in the dissemination of the videos and therefore loses its liability privilege. So we're back to, you may want to say, square one. Is an online video platform provider a neutral host, or does it take an active role? We've had previous cases, but the referring court is obviously of the opinion that these previous cases do not decide the question sufficiently detailed. We then have the YouTube case. It's again very similar. Does the operator of an internet video platform a service like YouTube, on which videos that contain content which is copyright protected and which are made publicly accessible by third parties, by users, without the consent of the right holders, carry out an act of communication under the Copyright Directive 2001/29 under certain circumstances. So again, a question which has not been asked for the first time, but the circumstances of the case are a bit different, and it again basically says, tell us, Court of Justice of the European Union, whether we have to understand the role of platforms today differently than when the Article 3 was conceived, or maybe also when the other decisions were taken. Two further very similar cases in the same context is Elsevier versus Yando. Does the operator of a shared hosting service, so file sharing service, via which files can be shared that contain also copyright protected information and which are made public accessible by third parties, by the users, does this operator of the hosting service carry out an act of communication? It's a bit different to previous file sharing network decisions, and that's why, again, will be an interesting addition. It's always about active communication. It's always about the famous Article 3, Paragraph 1 of this Directive 2001/29. The same applies for the next case, MICM, VPN. And here the question is now a technical variation. if the peer-to-peer network file sharing service allows the uploading of only parts of a copyrighted work, and maybe even really small fragments of these works, which is referred to as seeding. So basically a lot of bits and pieces are then put together again into something new, but each of the individual bits and pieces which are shared via the peer-to-peer network are per se completely unusable. They mean nothing, only when they're put together again. But is that then still to be regarded as a communication to the public? And then there are some other questions in that case that concern whether maybe for very limited amount of this type of seeding, it may then not be a copyright violation. There's also an interesting question about this happens without the user even being aware of which parts and when and to what extent of his own works, the works on the computer, are being shared. So does that maybe change the assumption whether or not there's been a communication to the public? And then also, what are license holders allowed to do with their licenses? In that case, it's about a company which basically only holds licenses in order to claim damages, and not because they are the own original authors. Why are all these cases so relevant and important, these four? Well, you should watch out for that, because in a way we now have the DSM Directive, the Copyright in the Digital Single Market Directive, and there the role of online sharing host providers is already different. And maybe the indications that the Court of Justice will give in these cases will already predetermine what the future copyright rules of the DSM Directive will have to look like in their national transposition. So look out for them. And the same holds true for, again, some data protection law cases which will have an impact on the media. There are several. One of them is the Ligue des droits humains, that's contre Conseil des Ministres, and that case concerns now not the GDPR, not the law enforcement directive, but now we are moving up to the third part of the data protection package that was published in the same official journal in 2016, and that is the Passenger Name Records Directive. And basically the referring court asks completely and totally, is this directive compatible with the GDPR and the Charter of Fundamental Rights? We have a German case, again, where the compatibility of the data protection rules which apply to Interpol are sufficient under GDPR standards, and whether or not the so-called red notices, which basically concern individuals that are put on a list, whether the further processing of such red notices is possible if the transfer of data from EU authorities or authorities under EU law to Interpol, which is not under EU law directly, is not governed by, for example, an adequacy decision. And a third one in that context, also interesting, comes again from Germany and concerns the applicability of the GDPR. Question is it applicable or not? And if so, how should it be done to an internal organizational element of a parliament? It's a parliament of one of the Länder in Hessen, and it's a committee in that parliament that is responsible for dealing with petitions of citizens. And the question is whether that processing is of a kind that others can ask for information about this data. So in how far they qualify under the GDPR as a processing unit. So again, I would say watch out for these, because they will have an impact also on the interpretation of data retention in general terms, how data can be retained, how it can be shared, how it can be forwarded, and therefore also on journalists and their work. And I may want to add that about 2 weeks ago, two further cases from the same referring court, which is a quite active court concerning data protection, that's the Verwaltungsgerichtshof Wiesbaden in the Land of Hessen, which also addressed the case that is mentioned here already. This court on the 15th of May and 2 days before asked in two separate cases about whether passenger name records, in the way it is done at the moment, is contrary to European law, and basically similar like the ECtHR case, whether at all the directive is compatible with EU fundamental rights law. And some of you will remember that the original data retention directive was crushed by the Court of Justice. Imagine the same would happen with the passenger name records. That would have quite an impact also on other types of data retention, for example, communications data of journalists, whether or not these can be retained. And with that, I would leave it with the Court of Justice and the view to Luxembourg, and would just wrap up as usual with a few hints on Strasbourg before concluding. And you can see already now that it is a very rich year, and I have the impression it's going to get more and more in the future, even though we already now have quite a lot of important cases. The same applies for Strasbourg. In Strasbourg we have numerous cases that would have been worthwhile reporting. I will just deal with a handful. And the first is the Center for Democracy and the Rule of Law versus Ukraine. As you know, in Strasbourg, individuals take cases to human rights against the states in which they reside for violation or claim of a violation of their convention rights. The case facts in the Center for Democracy were that this NGO was trying to make politicians more accountable in the Ukraine, and basically requested access to information that was held by the parliament, in principle their CVs, where they wanted to know if somebody that runs for parliamentary elections and has handed in the CV, which is necessary under Ukrainian law, they wanted to know what is written in there about their educational background and also about the history, what they had previously worked. And it was refused that they get access to these CVs because it was basically regarded as being something that was specific to the parliamentary election procedure. And the Court of Human Rights said, no. This NGO had an interest in the information which was legitimate, and that's why refusing it was absolutely not necessary in a democratic society, so it was disproportionate. It refers to an earlier ruling in a Hungarian case, which I have talked about previously. And the court applies a public interest test and says, yes, absolutely, these are leading politicians, they are public figures and especially prominent, and that's why finding out more about them is justified, and refusing outright access to their CVs is a violation of Article 10. So strengthened clearly the work not only of journalists but also of NGOs that basically do journalistic work of trying to inquire about in the sense of investigative journalism about the background of some current politicians. The second case concerns Hungary. It's I would like to say, a list of cases in the last 5 years or so that concern Hungary that are about how the regulation of media and internet is applied in concrete cases in Hungary. The facts in this case were that a television company in one of its programs had referred to a specific political party as being far right in the parliament, so far right parliamentary power. And Jobbik, this political party, didn't like it and complained to the national regulator, the NRA, which in Hungary is the MHH, and said parliamentary far right is an opinion, and an opinion was not possible and violated sections 12 of paragraph 3 and 4 of the Hungarian Media Act for that specific type of program. And the authority had the same impression and therefore imposed an injunction, and ATV went to the Court of Human Rights, and the Court of Human Rights sided with the television company and said that was a disproportionate interference with Article 10, absolutely not necessary in a democratic society because parliamentary far right is not exactly something which was a huge problem under this provision under national law. And the court was clear about this individual measure being a violation of the ECtHR, so the injunction. but it didn't question the underlying provision of Section 12 of the Hungarian Media Act, so it didn't want to interfere generally whether at all it would have is maybe impossible for the regulator and or already the national legislator to include such a provision which allows for such a decision. So, as usual, individual case only concerned the individual situation. In my reading of the case, it's actually quite critical whether such a provision under national law can be upheld, but it's not something that the Court of Human Rights can decide. The other cases I will just briefly mention, very briefly, 3 cases, and then that will be the wrap-up for today. One is, again, against Hungary. I don't know exactly how to pronounce the parties. I'm not going to attempt it. We call it the MKKP versus Hungary case. In that case, a political party was fined because it developed an app and shared it for the interested people. They could use it on mobile phones to actually make photographs of their ballot papers and then share it with others, basically showing we voted for the correct party in the perspective of that party. And the court did not rule on whether or not such a prohibition would be possible, that you can be fined for doing something like that, but it said it was at least unforeseeable. There was no legal basis which made it sufficiently foreseeable for the political party that there might be a fine if they develop such an app. So there was a violation, not on the substantive grounds, but because the law was not properly formulated or not sufficiently clear. And in the case of ECtHR versus Hungary, there is an interesting matter which concerns data protection in the or the activities that an employee can make. In that case, it was a bank employee who was running, besides his main job, a private website on human resources management-related publications, but also events. And the employer basically said, no, you're not allowed to do such activity. Your freedom of expression cannot relate to what you're doing in your work time, also outside of the work, and therefore terminated employment. And the question is, how much does free speech also count in the employment context? And the court demands from national courts, when they assess the situation, that they balance the interest of loyalty to the employer and the possibility to still be active and expressing your opinions, but also just conducting free speech in those fields that relate to your work. And the last case I want to mention is Pryanshinikov versus Russia, where the court says the authorities fail to strike a fair balance between freedom of expression and the need to protect public morals and the rights of others. It's about a rights holder who had rights to erotic film content, and then he applied for a specific authorization which he didn't get, referring to possibly a violation of pornography. And the court basically said it turned out later that A, he was not violating that other law, but B, the refusal of the authorization just because there was this other activity of Pryanshinikov was not justified. It was it didn't take into account the negative consequences it would have for the applicant, and the need to protect public morals or the rights of others were much smaller to be weighed in this case than the freedom of expression of the applicant, and therefore Russia was also found to be in violation of Article 10. With that, I went a little bit over time even in the online version, but the good thing is you can always press pause and return, and hopefully you did that and enjoyed the 1 hour 15-minute update on relevant and important jurisprudence, both in Luxembourg, Court of Justice of the European Union, as well as in Strasbourg, Court of Human Rights. If you want to find out more, please maybe also refer to our previous year's presentations, which are all accessible online, the ones that I do every year, the updates on the website of the EMR, and most of them also on the website of ERA. And let me finish with saying I really hope that in the coming year, if this is of interest for you, this topic, you will be able to join us again on a real conference in person, on site in Brussels. And having said that, I wish you all safety, health, and good work, and see you next year.